An amendment at the desk.
Ms. Spear has an amendment at the desk. Will the clerk please pass out the amendment? Without objection, reading of the amendment will be dispensed with.
Mr. Chairman and members, when young men and women raise their right hand and swear that they will uphold the Constitution and that they will protect our country, they do so knowing full well that by donning those uniforms, they may in fact lose their lives. They expect that they could in fact be in combat in a setting where they can become wounded. They do not, however, believe or expect that they are at greater risk of being a victim of violence within their own ranks than from the enemy. But that's basically what has happened in recent times. So this amendment and the one that follows deals with the issue of chain of command. The system in place now falls well below what is the standard that we would expect in civil society. The current system gives commanding officers, rather than trained and independent military prosecutors outside the chain of command, the power to decide whether or not to try a case. The perception and reality is that commanders with a built-in conflict of interest with no legal training are deciding whether to move forward to trial, not solely based on legal reasoning, but on a myriad of other factors like how well the defendant flies a jet, or is liked by others, or is a good husband or father or mother or spouse. A systematic lack of trust in the system is borne out by the numbers. This year's SAPRO report revealed that some 5,061 reports of sexual assault in 2013. Now, these are reports that were filed. 3,700 unrestricted reports and the rest being restricted. But of those 3,768 unrestricted reports, only 10% resulted in convictions. So what does that mean? Does that mean that only 10% of those that had the guts to come forward and file a complaint, who know full well that the system sometimes doesn't work on behalf of the victim, that oftentimes it's a career ender if you do file a complaint, that you're labeled with having a personality disorder, you become a pariah within your unit? Does that mean that 90% of the victims that have the guts to file a complaint are? I don't think so. In fact, most studies that have been done suggest that false reports amount to some 2 to 5%. Some argue that a convening authority relies upon their staff judge advocate to make those decisions. So it's not really the convening authority that's making the decision. It's actually the JAG. Well, that is not really the case. In fact, if you look at the Aviano case, General Franklin's staff judge advocate tried to persuade Franklin not to overturn the charges, but when it came to putting them in writing, the staff judge advocate balked and concurred with Franklin. You know, I have no interest in an innocent service member going to jail any more than I'm interested in a guilty perpetrator going free. In the General Sinclair case, there was, in fact, a negotiated agreement that was agreed to by both parties before trial, but the convening authority cut off negotiations and, in fact, under political pressure, evidently, made the case move forward. Many say the commanders need to own this issue. The truth is that the status quo isn't making them own this issue. So this First Amendment is quite simple. It basically is very similar to legislation introduced on the Senate side by Senator Gillibrand, and which has been co-sponsored on the House side by my colleagues Tulsi Gabbard and Dan Benishek. It basically provides that all non-military serious felonies be taken out of the chain of command, and that a chief prosecutor in each service would have the discretion on whether to prosecute a serious non-military offense. A JAG or an 06 or outside of the chain of command would then convene and carry out the court-martial.
Gentlelady's time expired.